Well, hello. My name is Mike Mowery. My profile is on UpCounsel. I've had over 30 plus years of legal experience with corporate and commercial transactions and some involvement in HR law as well. More recently, I've also had a career in the nonprofit sphere as a nonprofit executive and as an attorney who helps out nonprofits in building their organization and running them efficiently as well. What's described as Corp-to-Corp is basically a situation where there is another business that has been formed as an LLC or an S-Corp, for example, where you as the owner of that business are working with another corporation or company. You're responsible for your own taxes, which in some cases may be higher than what would be if you were an employee. You, on the other hand, have flexibility in terms of how you price your services as opposed to an employee. Compare that to a W-2 type situation where the person is essentially an employee. They may be working on a kind of a short-term basis, but when they are working, the company is treating them as an employee in terms of the pay scale and the some, if not all, of the benefits and the payment arrangements. They would typically be paid, every 2 weeks. Their taxes would be taken out, that type of thing. The other example is with a 1099. That's kind of halfway in between the other two examples. In a 1099, the contractor is usually not a business in the form of an LLC or an S-Corp. The contractor is simply working by him or herself. He or she must also still pay their own taxes. They should, if there's a liability concern with that individual, because you're not protected from liability issues like an LLC or an S-Corp would be. You have to set yourself up. You have to file your articles of organization for an LLC or your articles of corporation for an S-Corp with the state Secretary of State. You should have an operating agreement or bylaws to address the governance of your company. You are setting up a separate company to provide those services. There are different rules, the company that you're working for, in terms of how those services are distinguished between what an employee may be doing. In many states, there's what's called a right to control test to distinguish between what is truly a arm's length transaction between the company and the contractor vis-a-vis what would be the situation with an employee. So courts and state labor boards are concerned that a company may be, quote, hiring contractors and not treating them as employees and not providing them with the benefits, the work rules, the rights that employees would have. In California in particular, there's a test called the Morello test, which has I think 8 tests there are to distinguish between what really is an independent contractor, which could be then the C2C arrangement or a 1099 arrangement, versus what should be treated as an employee. One of them is whether the person performing the services is engaged in a distinct occupation or business of their own. Another test is this type of skill required for the particular occupation. Also, who provides the tools and the place of work for the person doing that work. If you're working in your own office, then you're probably okay. If you're working at the office of the company, then that would be one indication that you should be treated perhaps as an employee. Also, the length of time, if you're working there for 6 months, for a year, another indication that you might be an employee. The method of payment, and then finally, whether the parties really believe that they're creating a relationship between an employee or employee versus the independent contractor situation. And a state labor board would look into that, and if they thought that the company was kind of going over the line there, then could be penalties for the company. Interestingly, in California, I'm not sure about other states, but it's within the last couple of years that there was a Prop 22 that was voted for and it passed. It's technically called the California Apps-Based Drivers and Services Act. It's something that organizations like Uber, Lyft, DoorDash push through that tries to separate the drivers, for example, from what might be considered an employee situation. There are 4 different tests that a court or a labor board would look at in distinguishing the driver from what should be perhaps a employee relationship. The company does not restrict the driver from working in any other lawful occupation. So that separation of the driver from the controlling company are an indicia of whether this is essentially an independent contractor relationship or is an employee relationship. Well, thank you for watching. I'm again Mike Mowery, and happy for you to contact me on UpCounsel if you have any questions about this area. Take care.